They knew from the beginning about the dangers of lead, and yet they put it into their paint and they promoted it for use in homes and promoted it to children.
If it is so toxic for us, why are manufacturers continue to use something like that?
Well, they can't now in paint because it's been banned finally. But the lead industry, the mining of lead, was very aggressive, finding ways to use the lead to sell it. And they were very aggressive about selling it to the paint companies and for all the other different uses.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share part 2 of this conversation with Mary Alexander. We ended up down this path on the sex abuse cases and the bigger profile sex abuse cases from one of your first cases that you were working on. The other one that you mentioned was it sounds like some might refer to as a negligent delivery case. Anything about that particular case experience that informed your practice moving forward? For example, do you still do med mal? And I'll let you go from there.
I'm not doing medical malpractice. My practice began to shift more into product liability law and the sex abuse law, and the laws changed with micro, although it has gotten better lately. But what that case did do was really show me how my science and my medical background is so useful. I already knew how to read medical records. I know how to read the scientific articles, if there's epidemiology or even chemistry. I was deposing an expert in gas chromatography, and he was talking about the chemicals and running them through the gas chromatograph. And I just thought to myself, I used to run one of those gas chromatographs, so you're not going to pull anything over on me.
Have you found that an expert or defense counsel who has not bothered to do their homework about who you are has underestimated you?
Yes. And I do feel that I get underestimated, but sometimes it's an advantage because they maybe aren't as prepared as they should be. And then I can run circles around them. And I think that really being able to understand the science, epidemiology is hard and the chemistry is hard. And I actually had an interesting experience recently that I was giving as a speech and at a convention, and somebody was talking about carbon monoxide cases. And I had already given my speech and I had said something about being a scientist. So the guy giving the lecture on carbon monoxide cases, he says, Mary, picks me out of the audience. He says, why is it called carbon monoxide? And I said, because it has one oxygen. And he said, do you know what? I've had experts that couldn't tell me, 3 experts who couldn't answer that question. Supposedly experts on carbon monoxide. So just a little interesting backstory. So I just find that I use the science all the time.
I think that's a nice segue into the lead paint work, because I can't not ask you about that. That's such a significant body of work for what you have done. For those who have not heard about it, could you talk a little bit about what that case was? And I think it's a decades-long fight. Is that correct?
Almost 20-year fight.
And can you explain what it was and what you did as far as that case is concerned?
Well, our houses have lead paint in them that was put in California and California houses and throughout the country until lead paint was banned in 1978. But particularly in the in the early 1900s, 20s, 30s, 40s, into the 50s, there was a lot of construction and a lot of lead paint, and it never goes away. Lead paint is always there. The lead does not disintegrate. It's just there until it's removed, and it causes brain damage, particularly in children.
And this is the sweet paint. It's the one that tastes good, right?
Yes. But it's not just eating the paint chips, which is a problem and tastes sweet to children.
That was my very dry humor. I apologize for that.
It is really ironic that it tastes good.
Yeah.
By the way, I had an expert on the stand in the case, and I hadn't put it into my list of questions, but he's on the stand, and it just occurred to me to ask him that. So I asked him, I said, what does it taste like to children? And he looked a little surprised because he wasn't expecting me to answer. But I knew the answer to the question. I knew what he was going to say. And he said, it tastes sweet. The reaction, the look on the face of the judge was really extraordinary. Because you just think of something that toxic and that horrible should taste bad. But the problem is that children want to come back and eat the chips. But my point that I was going to make is it's not just the chips, but it's dust that comes off of the walls, and the children that are 3 years old go and chew on the windowsills, and paint gets used on the front porch. And so the dust then is breathed in by the children, or it does get in their mouths just from their hands, which exposes them to toxic levels. And so the purpose of our lawsuit was to protect children from lead paint, to protect them from lead poisoning.
From a lawyer and scientist perspective, between lead in gas, lead in pipes, lead in paint, if it is so toxic for us, why are manufacturers, say in the lead paint cases, why do they continue to use something like that?
Well, they can't now in paint because it's been banned finally. But the lead industry, the mining of lead, was very aggressive, finding ways to use the lead to sell it. And they were very aggressive about selling it to the paint companies and for all the other different uses. I was horrified to find out that the tinsel that I used to put on my Christmas tree as a child was lead.
Wow.
Our toothpaste was lead. Now it's plastic. But I mean, the kinds of exposures that I had as a child to lead were really, it's just amazing all the different ways. But the lead companies were really aggressive about finding use for the lead is really the answer to the question. One of the kinds of paint for houses was marketed that it was self-cleaning. So if your child put fingerprints on the wall or dirt, it would slough off. Well, that means the lead paint was sloughing into dust onto the floor. So it really was extraordinary exposure to children. One of the first studies was actually done in Australia, where children were getting lead poisoning from playing on the verandas of these large houses, and that's where some of the early studies came from. But you make a point about how ubiquitous lead was, and they finally banned it in gasoline. That was one of the excuses that was used in our case. Well, it's not the lead paint and it's all these other places and children getting exposed. But for example, even in our trial, the defendants were talking about how lead paint is used on the Golden Gate Bridge. That lead paint is used by the state of California along the highways for the fences, and that's not where the children are. They're not chewing on the Golden Gate Bridge, not chewing on these fences along the highway. They're chewing on the chips in their houses and the windowsills. What matters is where the paint is being used in the home with little children.
I think of a general personal injury case, and a client comes to you and says, how long is this going to take? And I'm like, anywhere from 2 to 4 years, maybe longer if there's an appeal, but, that's kind of a range. 2 decades is a long time. Can you kind of unpack the machinations of this case, kind of its arc and then its resolution?
Well, I was very pleased to be asked by the city and county of San Francisco to represent them in going after the lead paint companies. The first county to file was Santa Clara County, and all the counties. We ended up with 9 of them in 2000. The short answer to why it took so long was all the appeals. But we filed a complaint in 2000, and the lead paint companies, really led by Sherwin-Williams, but lead paint companies filed a demurrer. And our very first time in court was for the demurrer, and the judge granted it.
First demurrer?
First
grant
demurrer.
Without leave?
Yes.
Wow.
So up we went on appeal. Let's just say what we were left with after the appeal was public nuisance, not negligence or product liability or anything like that. Public nuisance. That what lead paint in our houses is a public nuisance. Now, one thing about public nuisance is it continues. There's no statute of limitations. Until the nuisance is abated. So that's basically the case was that we were asking for abatement then of public nuisance. And we became basically attorney generals. We were representing the people. In fact, we were calling it the people versus the paint companies. And we would stand up in court and say, we're here for the people. So it was to get funds for the public entities, for the counties, to remove the paint from homes to protect the children from lead paint poisoning.
The parallelism that immediately comes to mind is the tobacco work, where states brought in firms to represent them in those types of cases. I also know, present day, the city and county of San Francisco does affirmative litigation, say in the opioid cases, where they have their own lawyers. Did you work in parallel with city attorneys? Did you handle this on your own? Are there still private attorney general actions like that? Is my question too long?
It's a very good question. We did work side by side with attorney for each of the public entities. And we made them very involved in the case. The trial. They were there every day. And we had them put on their own witnesses, from their county. We would do the experts and some of the other witnesses. But we felt it was very important to have them involved. And they were great. They wanted to be involved. The parallel is with regard to tobacco industry is a very good point you make. And it's even probably more than you might realize. Lead paint companies, just like the tobacco companies, promoted their product to children. They would hand out in the paint stores and other places little coloring books for children. And it's a gloomy day, but then the nursery gets painted these beautiful colors, and it's a bright, beautiful day. And give this coupon in the back of the book to your parents in order to buy this paint.
Wow.
And it was a coloring book, and so they could color it. And they did exactly that, promoting to children for the lead paint.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts. And consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. Getting to resolution, how did you line it up? Was there a verdict? How did it end?
After 2 appeals, one of which went all the way to the California Supreme Court, and we had a great opinion by Chief Justice Ron George. So the case came back down. We eventually, in 2014, so now we're 14 years out, had a trial. And so it was a judge trial because this is nuisance. And so not before a jury. They wanted a jury, but that's not what the law is. So we had our experts lined up. Number one was somebody, a physician, a pediatrician, to talk about the effect of lead paint on children. Like, why are we here? What's the danger? The brain injury that it causes. An industrial hygienist to talk about the exposure and the dust and what the levels are, and then chemists and other people to talk about the lead paint and how there are just that there are safer paint, and also people to talk about what they knew. They knew from the beginning about the dangers of lead, and yet they put it into their paint and they promoted it for use in homes and promoted it to children.
So the outcome, the judge issued an award, a verdict, written opinion?
Correct. Written opinion, it was like, 50 pages or something. And we had asked for 900 something million. His was $1 billion, and then he actually added on to it another 50 million. So it was $1.05 billion. I have to tell you that it really, that number, as big as it sounds, is not enough to remove all the paint. And what he did was he calculated what it would cost to remove from the houses the most dangerous parts, like the windows, like the doors, and because those are the ones that generate the dust the most, windows opening and closing, doors opening and closing. So that was really only to target that, not on all the walls or the exterior walls.
From the trial itself, any experiences, any testimony, any work with experts that were particularly compelling as far as what happened in the case?
Well, we had this fabulous physician, pediatrician. He's now in Vancouver, but he did the original study, by the way, at the University of Cincinnati, where I had been.
Of course.
And he did some of the original research on looking at children in neighborhoods that had lead paint and comparing their IQ and those neighborhoods to neighborhoods where they did not have lead paint, showing what the difference is, and actually going out and testing the homes. And so there was really solid evidence that lead paint causes brain injury, reduced IQs in children where they live in houses with the lead paint. And he was a very dynamic person. We had a PowerPoint, and he talked about, first of all, just the dangers of lead in general, all the way from having some mild symptoms to severe brain injury to death. It can kill you. During that is when I asked him about what it tasted like. But I was just about to ask him, which was in my script, how long has it been known that lead is poisonous and toxic and causes brain injury? When the judge turned to him and said, how long has it been known? And the expert said, since antiquity. And that line showed up in the judge's opinion. I think it was also startling to the judge. It used to be called plumbism, the effects, let's call it, it's not really a disease, but the effects was called plumbism because the people who were building bricks and brick walls and building buildings would have the plumb line, which was lead, and they would be exposed to that lead. And so that's where the word plumbism came from. But there's some theories. One reason he's talking about antiquity is that in Rome, Roman times, the Romans would put their wine into lead containers. And some people have opined that's what caused the fall of the Roman Empire. I don't know if there's proof of that, but that's just to say that there was a lot known about the exposure to lead back then.
I think we have kind of gotten there mostly in terms of the damage element by using the phrase abatement. But when you say abatement and the calculation of damages, how, I presume some experts were presented to talk about what it would take to try to abate it.
Yes, we had experts that were able to calculate that. It's actually very expensive to remove it. And one of the reasons is you just can't go in there and start whacking on the walls or taking out windows because you're going to create dust, not only in that home, but in the neighborhood. And so there's all these rules about how you have to have plastic around to keep it in. And the people come in have to be in hazmat suits. I mean, it's extremely expensive.
I'm smiling only because, we have an old Victorian and the sanding work, any sort of work where there's more detail work when we've been doing it in the house has required some significant expenditures for exactly that kind of thing.
That's right. It's very expensive, which is one reason why it was important to get the money from the lead paint companies, because for homeowners to do that, it's very expensive. People can't afford it. Or people live in apartment buildings with it, and the landlords don't want to spend the money, or they don't have the money because it's so expensive. So we had experts that talked about that. And later, when the judge was actually writing his opinion, he wanted to have more detail from us on what was the cost just for the windows and the doors that he wanted to do. So we also had to have experts that talked about their promotion, because we had to prove that they promoted lead paint in California. So before the trial, I sent a team of people to the San Francisco library to look in microfiche for the newspaper articles back to the early 1900s where they were promoting lead paint and showing that they were selling it here in California.
What kind of an expert do you get to testify about promotion?
There were a couple of experts that had written books already on lead paint and promotion and lead paint companies, and they understood a lot about the advertising and promotion. So they testified to that. And we presented to them what we had found on the ads, and so then they used that.
Anything else that we should talk about with the lead paint cases before we move on?
Well, what it meant for us to try the case in 2014 and to get the verdict was really a culmination of an extraordinary effort. But then it went up on appeal. And it wasn't until 2019 that the decision came down. And some of it was actually taken away because of the promotion. They thought there wasn't enough promotion after 1950. So, but then eventually it did settle.
Two additional questions came up for me. One is there now an abatement fund or something that people can take advantage of if they are doing work with their homes?
Some of the counties have set up such assistance, and so it's really by county by county. We had Santa Clara County and San Mateo County, San Francisco County, L.A. Needless to say, L.A. was really a lot of houses, and Ventura County and some in San Diego too.
And you said it settled, so I'm going to presume that you did not have to take another path down the bankruptcy road.
Correct.
That's nice to hear, given that number.
But one reason why they fought so hard is just think about the entire United States, how many houses there are that had lead paint. And they wanted to discourage other counties and other states from pursuing it. We do have really good law, I have to say, in California, the public nuisance law, that we were able to take advantage of.
Are you aware of any other places going down the same path? In essence, this being a trailblazer case as far as lead paint is concerned.
I think that there had already been some work that was done in Massachusetts and in Wisconsin and a few other states. But it's not for the faint of heart because of the way they turn it into a 20-year battle.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.